Hey, I'm Paul Rabelais, and in this video, this is video number 1 of a 5-part series on how a married person leaves their estate. All right, so you're going to want to check out all 5 of these videos. I'm going to do them one at a time, probably one every day, but it's an important and often overlooked aspect of the estate planning process of really digging in deep on what happens when a married couple has a legal program in place and one spouse dies. What are the rights and obligations of that surviving spouse, the kids, the other heirs? There's really 5 different scenarios, and I'm going to dig into each 5. This one is just kind of option number 1 or scenario number 1. Let me go through all 5, then we'll jump into scenario number 1. The scenario, and I'm going to name them, but you won't understand them until we go in depth. The first scenario is when one spouse dies, it's all to the spouse. Second scenario, one spouse dies, that spouse's estate is in trust for the surviving spouse with the surviving spouse as trustee. Scenario number 3, first spouse dies, that spouse's estate in trust for the surviving spouse where the surviving spouse is not the sole trustee. Fourth scenario is not the spouse, and fifth for you Louisiana folks, usufruct. We'll talk about that in scenario number 5. First scenario, let's dig in. And so I'm excited about this 5-part series because it's just such an important aspect, and I'm excited about maybe educating some folks about this. All right, so this is not a will or revocable living trust conversation. There's lots of conversations and lots written about whether you should have a will where your survivors go through probate or succession in Louisiana, or whether you should have a living trust and enable your survivors to avoid that probate process. This is not that discussion. So the things we're going to talk about, they can be done either through your will or through your living trust, either way. So we're going to kind of dig deeper. All right, so this is a, you're married, or maybe you're getting married. Maybe you have children, either with your spouse or children of your own, or you have just other heirs. And there's you may not realize it, but there's likely to be some kind of competing interest when you pass away between your spouse and the other heirs that you may be wanting to provide for. So that competing interest is really what could impact your decision on how you set things up. Okay, so this is I'm going to leave it all to my spouse scenario number 1. And if it's done through a will, your will might say, I leave ownership of my entire estate to my spouse. Or if it's done through your revocable trust, your trust might say, when the first spouse dies, all assets remain in the trust, and the trust is completely revocable by the surviving spouse. So that's kind of the slang language that's used. Now, I will tell you, in the living trust world, this is not a common scenario under the kind of sophisticated estate planning concepts. And I'll tell you why. Because years ago, now maybe decades ago, when the estate tax exemption was only $600,000, the first spouse to die would never want to lump his estate into the estate of the surviving spouse, because it would often cause the surviving spouse's estate to be valued at more than the $600,000 exemption, and it would cause some unnecessary estate tax at 55% of the value of the assets on the date of the surviving spouse's death. So it was not common for living trusts to enable the surviving spouse to completely control everything, because that lumped everything into the estate of the surviving spouse for estate tax purposes. So just about all living trusts, certainly all of them back when, and kind of just because it was done then, it's done now. Many of them you see are set up so that when the first spouse dies, it's not all completely revocable by the surviving spouse. Things go in a trust, and so the assets of the first spouse to die are not lumped into or included in the estate of the surviving spouse. But now You can do that. You can lump assets into the estate of the surviving spouse. In fact, it may make good tax sense to do that. It's not a penalty to lump assets into the estate of the surviving spouse because we have an $11.4 million estate tax exemption. It just doesn't affect many families. And plus we have something called portability, which even if you do lump assets into the estate of the surviving spouse, it enables the surviving spouse to potentially use 2 times the estate tax exemptions, or $22.8 million, all free of what is now a 40% estate tax. So it's okay now, if you're setting up a living trust, to provide, it's okay from a tax standpoint. There's other factors, but it's okay typically from a tax standpoint to allow that trust to be completely revocable by the surviving spouse. And oh, by the way, another tax benefit, assets that are lumped into the estate of the surviving spouse get another step up in basis when the surviving spouse passes away. So things get this double step up in basis when you leave everything to your spouse. So the all to spouse scenario hasn't been common in the living trust world. It has been kind of common in the, oh, just give me a simple will and I want to leave everything to my spouse. That has been kind of common over the years. So, all right, so let's dig into what all of that means. When you see a married couple set up an estate legal program with thought, and they left everything completely for the surviving spouse, you see that a lot in the traditional families. And by traditional, I mean husband and wife. They have children together. Kind of not unlike my family. My wife and I, we have 5 children together. And so those couples kind of feel like, I just want to make it easy on my spouse. I can't envision my spouse leaving it when my spouse dies to anybody other than our children. I'm okay. Let's just let the surviving spouse completely own and control everything. So you see it in the traditional families. Here in Louisiana, you really can't leave everything to your surviving spouse if you have forced heirs, which are defined as children when you die who are 23 years of age or younger, or children of any age who are incapacitated. A lot spoken on other videos about forced heirship. But be aware that you can't leave everything to your spouse if you have forced heirs. Now, I mentioned the double step up in basis. That's a good thing because especially in community property states, or particularly in community property states, when the first spouse dies, all of the community property gets a step up in basis. A lot of people don't realize it, but that's a good thing. And then if you lump everything into the estate of the surviving spouse, then it all gets another step up in basis when the surviving spouse dies. So it eliminates capital gains tax or tax on appreciation from the time that the first spouse dies until the time that the surviving spouse dies, which who knows how long the surviving spouse will live and what will appreciate and how much, but that could be a big benefit to your heirs, to your children. Okay, now some of the downsides of this leaving it all to your spouse, and it's a little easier for me to say this into an iPhone camera than it is to a couple who's sitting across the desk. I'll just leave it at that. So when you leave things to your spouse, if your spouse ends up getting remarried, or even if they don't get remarried, your spouse is going to be in control of 100% of everything you have. And your spouse could, in theory, or in reality, leave your entire estate and your spouse's entire estate to people other than your children or people other than who you'd want to get it, at the end of the day. So if, that's what some married people are concerned with. I don't want to leave everything to my spouse, and then my spouse goes and meets somebody, Prince Charming, whatever, gets married and leaves it all to Prince Charming and leaves my children nothing. So, and then if you leave everything to your spouse and your spouse either, I got a slang term, just does something stupid, or doesn't necessarily do something stupid, but in their older age, they get influenced by the wrong person and they sign something that could mess up, leaving things to the kids. So it would just take perhaps one signature to really screw up everything. So there's some potential downsides to leaving everything to your spouse because of that kind of competing interest between your spouse and your children or other heirs. So who does this? Who leaves everything to their spouse? Well, I would say the people who just are comfortable leaving everything to their spouse so their spouse can do whatever they want to with it. Maybe their biggest goal is providing for their spouse and allowing that surviving spouse to completely control everything. So some husbands say, my wife put up with me. We worked on this together. My wife sacrificed. I just want to leave it to her. She can do what she wants to with it. I'm comfortable with that. Others may say, along the same lines, protecting the kids is not a primary goal. I just want to kind of keep it simple. Sure, if my kids ultimately wind up with this double step up in basis, that's great. And they'll get that if I leave everything to my spouse and allow it all to get another step up in basis when my spouse dies. Maybe that's who does this. Maybe people don't care what their spouse does with it after they pass away. Maybe you just know, kind of like I do, that if you pass away and you leave it to your spouse, there's no way your spouse is going to do anything other than leave it to your kids. So those are some scenarios. It's not really an estate tax discussion anymore unless you're really wealthy. I guess married couples with, really maybe 10 million plus. Probably need to start looking at these decisions in terms of what are the tax consequences to it. But it really isn't an estate tax driven decision. Could be somewhat of a capital gains tax driven decision. So that's it. Scenario number one, married person leaves it all to their spouse. Spouse completely controls it. They either do it through their will, I leave everything I own when I die to my spouse, or they do it through their revocable living trust. My part of the trust is completely revocable by the surviving spouse. And there's the double step up in basis. The spouse has complete control. There's no real protection for the children or other heirs that might be okay or not okay. We're going to cover some of those protections in the other four scenarios, but this is the one that's kind of simplest for most people to understand. I'm going to leave it all to my spouse and leave it at that. Okay, hope that helps. Stay tuned tomorrow or check out the other videos that I do subsequent to this on the 5 scenarios or 5 ways a married person leaves their estate. This is number 1, all to spouse. Hope you enjoy it. Comments below. Punch the subscribe button with the notification bell. Give it a thumbs up like. Y'all have a great day. Take care.